Okay, before we get started, this account was created to provide information on how current immigration laws apply to certain factual scenarios. There are many people, I suspect, who are worried about their immigration situation but are not sure if they should speak with an immigration attorney. Keep in mind, and I cannot stress this enough, that immigration law is unbelievably fact-specific. So even if the hypothetical that I analyze here sounds nearly identical to your situation, you still need to speak to an immigration attorney. The smallest factual differences can change everything. That said, this is not legal advice. I'm merely hoping to educate some people on how the immigration laws work, because I know that a lot of anxiety exists out in certain immigrant communities. Also, immigration laws and procedures will likely change significantly over the next few months, so what might be accurate and current at the time of recording could be outdated in the weeks to come or even tomorrow. This individual entered the United States from Mexico with a B-2 visitor visa in 2013. He entered legally, but he overstayed and he never left. In 2018, he was stopped by ICE and placed in immigration court for deportation proceedings or removal proceedings. In 2021, his immigration attorney was able to discontinue his removal proceedings. In 2023, he married a U.S. citizen and they remained together. The couple would like to know if they can legalize his immigration status. This person entered legally. They are currently married to a U.S. citizen. So we can pursue a case for him through his U.S. citizen wife. All right, we can do an adjustment of status. Now, the big question is, what exactly happened in immigration court? Okay, we know that his deportation proceedings or removal proceedings were discontinued a few years back, but there's two ways that that could have happened. So one would be an order to dismiss the case. Okay, or terminate the case. That's where the judge completely stops the case. It's off the court calendar, and there's no pending charges against him in immigration court. All right, so that would be a dismissal of the proceedings. The other thing is that it could have been administratively closed. Now, those might sound very similar, but they are different. If you have an administratively closed case, it means your case is still in immigration court. You just don't have any hearings scheduled, and the government is not actively pursuing your deportation. If you have an administratively closed case, you cannot get a green card through USCIS without going back into court and getting that administrative closure turned into a dismissal. Okay, so the very first thing we would have to do here is get the court records showing exactly what happened in 2021. Was it a dismissal or was it an administrative closing? Once we've figured that out, then if it's a dismissal, we're fine. We can go forward and we can get the adjustment of status depending on what office this couple's processing in. That could take as quick as 4 months, maybe 6 months, something like that. If the case was administratively closed, then what we need to do is file a motion to recalendar the case with the immigration court, so we get the case back onto an active docket, and then we move to dismiss the case and get it kicked out entirely. And once we do that, then we can go for the green card through USCIS. A lot of different terminology in there. Hopefully this sheds some light on the situation. If you have a situation like this or a loved one does, call an immigration attorney. If you'd like our help, you can reach out. We have our contact information below. We're happy to meet with you, figure out what's going on with your situation and what options we have. Other than that, everyone, take care of yourselves. Good luck. I know it's difficult out there these days, but keep educating yourself, know your rights, and hopefully everything works out for all of us. Take care.